Copyright is the intellectual property right that protects the creator of original literary and artistic work. This is quite broad. Think about movie, music, choreography, comics, poems, or even a few words. For instance, a tweet or the book title can be copyright protected. And the copyright protection is automatic, so it will grant you a set of exclusive economic and moral rights from the moment of the creation of the work. Economic rights means that you are the only one to be able to decide who can use your work, who can reproduce, communicate it, translate it, adapt it, and under which condition. And moral rights have the right, for instance, for you to have your name on the work. This is the paternity right, or the right to defend the integrity of your work. And unlike the economic rights, the moral rights are attached to the person of the author. They cannot be traded, they are inalienable. So it means that each time someone wants to use your creation, they will need to get your prior authorization. This is what we call the all right reserved principle. And it means also that each time you want to use someone else's works, you will need to get his authorization, and most of the time it will go through a license. Of course, there are nuances. There are exceptions to copyright. In some cases, you don't need to get this prior authorization from the author to use his work, for instance, under parody exception, caricature exception, quotation exception, and private use exception. And there are also another nuance, which is the fact that copyright protection is not indefinite. It lasts until 70 years after the death of the author. It means that you don't need to seek the author prior authorization for works which is in the public domain. Concretely speaking, design clauses can be copyright protected, but only their original feature resulting from the creator's free and creative choices. It means that functional or utilitarian component of a design cannot be copyright protected. Think about the form of a jacket, the form of a trousers, of a glove, because their realization is dictated by the curves, the human anatomy, that they cannot be copyright protected. And something else important for the fashion world is that copyright does not protect ideas or concepts underlying a work. They are just protecting the expression of it. So you cannot be blamed for creating a work fitting the fashion tendency or for drawing inspiration from others. It's only when you copy other designer part which are expressing their personal touch, then it can be copyright infringing. And how to assess whether you go beyond the inspiration, whether it becomes to be a theft? Well, this is an issue for national judge. Most of the time, they will look at the overall pictures of the two objects and give more consideration to the similarities rather than the difference. So it means that if there are small differences, it might not be enough to conclude to inspiration, above all if you have been reproducing some original component of the first work. So my advice for you, young designer, is that ideally you should design the project independently without imitating, copying original creation of someone else. And if you decide to voluntarily reproduce some original feature of a pre-existing work or clothing line, for instance, then make sure to ask the prior authorization. First of all, let me remind that ideas and principles underlying a work are not copyright protected. It means that a painter cannot be claimed to be plagiarized if you are just imitating a process or following his style. It means also that you can draw on others' ideas, but when those ideas are concretely expressed in a form, then reproducing that expression can lead to copyright infringement if you do not have asked for the prior authorization. And I can give you a concrete example of Paris case where an American artist, Jeff Koons, was sentenced for the exhibition of a sculpture copying a photo from a French artist, a photo called Fediver, created for the fashion brand Naf Naf. And the judge first confirmed that the photo of the French artist was original. It was the first step. And secondly, looking at the sculpture and at the photo, the judge ruled that in spite of small differences, because indeed the sculpture was adding two penguins and a garland flower, while this cool sculpture was essentially the David da Vinci work in three dimensions. It was representing the original element of the photograph in particular its composition, the woman with the beak. And the court also said that the parody exception could not apply in that case because there is no reference, no mention of the source of the first work. And when it comes to those derivative work, so you could totally work on adaptation, on translation, and on arrangement of music, for instance. And you could totally also get copyright protection for this adaptation, for this derivative work, provided that you can prove that you added your personal touch. But it's always important to remember that in that case, you need to obtain the permission of the creator of the initial original pieces, unless, of course, if this original piece is in the public domain. Well, sampling means that you reuse, you reproduce a fragment from an existing song, a bit of a piece of a text. And as said before, every copy, every reproduction of sample of music, or every time you upload a song, even if it's only a fragment of it, then they are likely to amount to copyright infringing act and require you to ask for the prior permission. So I would say that the safest option is to ask the permission to the record company before using a sample of music. Or you can also go through the collective management organization responsible for music in your country. And just to tell you that in law, there are also some nuances sometimes, and recently an European judge has said regarding sampling that the use of a music sample was not a reproduction in the sense of the copyright law when that sample is not recognizable for the human being. So the bottom line is that if a sample is unrecognizable to the ear, then there is no copyright infringement. And that judge also opened the possibility to apply the quotation exception in case of sampling when there is a dialogue between the two works. And of course, I just would like to finish saying that everything we said before does not prevent you from downloading music from internet, from making arrangements of music, provided this is done for your private, non-commercial purpose, for your family circle, because this is of course falling under the private copy exception. I would like to thank you for your question. Would you have any other question on copyright? Please do not hesitate to reach out. Bye bye.